Yeah, we wanted to talk about title and basically kind of go through every way an individual can hold title, whether or not they're coming in buying a property, if they're single, if they're married, or even if they, are buying with a partner, like maybe a family member or just a friend.
Right.
So I want to kind of go a detailed structure of all those breakdowns, and then why you would use a certain way versus another way, and then we can kind of go into right of survivorship and why that's a benefit as well. um, Community property versus joint tenancy. So cool. So let's start, like, if I'm a single person just buying on my own. Let's go. We'll start there.
Right. So typically, the way things will get titled is Brandon Feco is, a single man is sole and separate property. Right now, is that optimal? Uh, the problem with that is that if you or when you pass away, what happens to the property? Well, that it has to go through probate,
Hmm.
and typically in probate, whoever is responsible for the estate, you cannot sell the property, you cannot refinance the property. You basically can't do it a whole lot with the property unless you get a court order. And the way a probate works is that once the probate's opened, you have to do what's called marshal the assets, which basically means you have to bring the assets in front of the judge, and so the judge knows what the estate consists of. Then you have to notify the creditors. So this takes months,
Okay.
and during that time, you still have to pay the mortgage, still have to pay the insurance, still have to pay property taxes. All that stuff still has to be taken care of, and you can't use the property to do it. So you can't refinance it, you can't sell it. It's frozen.
So
And
let's say I'm just a single guy with no kids, no family or anything. What do I care kind of what happens when I go?
well, that's the question: is do you care,
Yeah. So
right?
but I mean, let's say I am single, usually somebody has parents or a sister or
Or-
something, like,
Right.
you want to make sure your house doesn't go to the government, I guess, right? Is that what would ultimately happen? Or
Well, if so, everybody has a plan. It's either
Mhm.
the state's plan or your estate plan,
Okay.
right? So under California law, uh, single person dies, they own property. So now we have what's called intestate succession. Now, if you were married with children, half of the house would go to your spouse, and half of the house would go to your kids, which is usually not optimal.
Okay.
If you don't have a spouse and you don't have children, then you're looking at your parents, or you know it's all in the probate code. You just kind of check down the boxes. Uh, if you have a will, you can leave your house to whoever you want, but it still has to go through this probate process. And there's no guarantee that the house will go where you want it to go, because the judge might decide, you know what, we're going to sell that house to pay the creditors,
Mhm.
right? So the house is gone, the creditors get paid, and the person you wanted to have the house is out of luck. So my preference for a primary residence,
Mhm.
I always want to see it in a living trust,
Got it. Okay.
right? That way we
Okay.
avoid the whole probate issue. We don't have to go to the
Yeah.
judge, um, and it's not that expensive. Probate's expensive,
Okay.
and in
Yeah.
LA County, last time I checked, it's
And
like
time.
a couple of years, right?
So what happens, I'm curious, what happens, I pass, I'm single, my house goes to probate, but I have a mortgage payment. What happens with that mortgage? Does it just like who pays that? Who if it's in probate, how would that work?
Right. So someone has to pay it, and if they don't, then the house gets foreclosed upon.
So it'll eventually just go to foreclosure, if nobody takes it over, nobody starts
Yeah.
paying on that mortgage.
Yeah, that's why banks secure
Yeah.
the loan with the property is if they
Yeah,
don't get
yeah,
paid, they can sell it at foreclosure.
yeah, okay. So as a sole ownership, you have single person, we have an unmarried person, which means they were married but now divorced, correct?
Hmm.
And then you have a married person you can hold sole and separate. So I buy a house, I don't want my wife on it.
Right.
Sorry. Sorry, honey. This is mine. But even with that, let's say it's married, sole, and separate, but we live in California, so I mean technically it's still half hers, right?
Well, it might be. Uh, you know, if it's community property, yes. Um, it's not.
Well, that's I
You
mean,
know,
we're in California, a community property state. So
right.
no matter what, if I hold that property sole and separate, she's technically still owns it.
Not
Um,
necessarily. Let's say
no? Okay.
you had an inheritance, right?
Okay.
Let's say you inherited a couple $1,000,000. That's your sole property. And then if you use it to buy a house and you don't do what we call co-mingle, your the funds, that house could be your separate property. So in
Hmm.
California, there's community property, but each spouse can have their own separate property too,
Hmm.
right? Now, the practical reality for most people is everything gets commingled and it just becomes community property,
Yeah. Yeah.
right? So you inherit a couple $1,000,000, you deposit that into the joint checking account.
Hmm.
People are buying groceries and paying the car payment, and now it's like, how do you track those dollars? You
Yeah.
don't.
For
So
sure.
now it's commingled and it became community property. But
Gotcha.
if you say, I'm going to open up my own separate account and denote that account as my separate property, and my inheritance goes in there, uh, now we can track it and say, yeah, that's separate property.
Okay. But bottom line, let's just say situation here. I have a kid. I get married, obviously not with the mother of my kid. And I inherited this house, which I want to make sure goes to my kid if I die and not to my new wife. The best way to do that is just put it in a trust and just,
Yeah,
you know,
what I would do is I would yeah I would have a living trust, put the property in the living trust. If there's a mortgage on it, I would probably encourage you to uh, get life insurance,
mm,
and so that way, when you go, if that
hmm
mortgage is still there, there's an immediate influx of cash into the trust account that can pay the mortgage, that can pay the property taxes, that can pay the homeowners insurance, that pay the HOA or whatever needs to get paid, right? And your kid's protected.
Yeah, that makes 100% sense. Okay, cool. So let's see. The next way is joint. So I'm going to buy this with my wife. I can
Mhm.
do what? Joint tenancy and tenancy in common. What's the difference? And
Right.
I guess
So
we can throw on right of survivorship to joint tenancy. So go into the details of those.
right. So joint tenancy, the reason people use it is it's kind of like what I call a poor man's estate plan.
Okay.
Uh, so when one of the spouses dies, the other one automatically owns the property, themselves, because they're the survivor. There's a lot of
Which
drawbacks to
so
joint tenancy.
100% of that ownership will go to my wife if I
Right.
have joint tenancy.
Right. So there's some drawbacks. One is
Okay.
you don't get a full step up in basis. So let's
Even
say,
with okay, just joint tenancy alone,
right, with joint tenancy, it's a half step up. So
half step.
you right. So let's say you buy a house for $500,000. It's now appreciated to 1,000,000,
Okay.
and you die. the tax basis for capital gains purposes will not get stepped up to a million. It gets stepped up to 750,
Oh, wow. I didn't know that. Okay.
right? So the step up in basis is you lose half of that step up. The
Interesting.
other problem is people assume like a certain sequence in death, right? It's like we're going to assume that I die first. Well,
Yeah.
maybe you don't. Um, and there's nothing that says you guys could go out to dinner and be in a car crash and both of you go at the same time,
Yeah.
right?
Yeah.
So now there's no survivor.
And then we go to
Now
probate, right?
you got to go to probate,
Yeah, same thing. Okay.
right?
That makes sense. Now,
So,
let's say we do joint tenancy with right of survivorship. Does that
well,
give me the
joint
full step
tenancy,
up?
by definition, joint tenancy is right of survivorship.
Oh, it is. Oh, okay.
There's no such thing as a joint tenancy without it,
Gotcha. Okay.
right? Now, the most complicated one I've ever
I don't usually see joint tenancy with right of survivorship on title. Usually I just see joint tenancy. So either way, however you phrase that on title, it doesn't matter. It's the same thing.
right. By definition, that's
No.
what a joint tenancy is,
Okay. All right.
right?
Um,
So,
okay. And then what? We have tenancy in common. That's another option.
right. So that's where your tenancy in common is each person on title owns a uh, undivided interest in the property. So let's say you and I buy a house together as tenants in common. We would each own half the house, but it would be undivided. So it means I have just as much right to use all the property as you do. And then when you die, I still own my half.
Mm.
Your half needs to go somewhere, and if you haven't planned for it, it's going to get probated.
Okay. So how would I plan for that? If my house is not in a trust, I have it tenancy in common. I own half this house. I pass, and obviously I could have a will that says my half goes to my wife or my kids or whatever, or
Right,
whoever's not the other half. Um, a will, could that would that still put it in probate? Because I know wills aren't always the best
right.
thing.
So the only time a will is effective is you have to die first.
Hmm.
The will gets lodged with the court. You open the probate, marshal the assets, pay the creditors, and then after all the creditors are paid, the judge will then look at the will and try to give effect to it, which may or may not work.
Okay.
Right? If he sold your half of the, he might decide, we need to sell Brandon's half of that house in order to pay the creditors. So now I've got a problem because I gotta pay your creditors.
Yeah, that makes sense. So, could I have a trust and basically I hold the property tenancy in common, but how do I make it go to my trust if it's not in the trust? I guess is that possible or like would it have to be
Right.
titled
So
into the trust? How?
so this is where things start getting complicated. I like to keep them simple. What I would probably do is recommend doing a joint trust between you and me. Right? There's no rule that says it has to be just yours or just with a spouse. You and I could have a trust.
Mhm.
Right? We could call it the Chris and Brandon House Trust. And then that trust document, trust is just a contract. So that trust document would then dictate what happens to the house when one of us dies or both of us die. So you might say, in the event of Brandon's death, his one half undivided interest in this property will go to your spouse or to your kids, right? And in that trust agreement would spell out how everything is handled.
Okay.
But it's also you have to ask what is the purpose of the property? Why'd you buy it? Are we
Yeah,
living in it together?
why are you buying it with a partner or
Right,
I mean eh, or I guess in this case, tenancy in common with my wife, just because we do tenancy in common, because I want half of my ownership to go to my kids. and if I die, and then she wants half her ownership to go to her kid when she
Right.
dies, would that work? Or how or is still just you
Right.
gotta kinda do a trust to make
Yeah.
that
So if
happen?
this is your primary residence, I mean, what I would, the way I would recommend planning this, again, you're going to use a living trust for this.
Yeah.
If Angie dies,
Mm.
you don't want to live with her kids. If you die, Angie may not want to live with your kids, right? It's
Mhm.
right. So if you give half of your ownership, your tenant, your piece of that uh, house, they have just as much right to take possession of and make use of that house.
They could just move on in because they're half ownership
Right. Well, it's like,
and
hey,
then
free rent.
wow.
Uh,
Yeah.
and I'm sleeping in the master bedroom. I don't know where you're going to sleep, but I'm sleeping in the
Yeah.
master bedroom. I'm gonna This is my home. I'm gonna walk around in my boxer shorts. I'm gonna be lying on the couch watching sports, scratching myself, drinking beer, and sorry if that inconveniences you.
That's crazy. I mean, that could be a big problem if you don't have a good relationship with somebody else's
This is
kid and
why,
things like that.
yeah, this is why
Yeah.
people invest a couple $1,000
Okay.
and you plan it out and say, well, honey, if I die, I want my child to have the value, the equity, but I don't want them to be able to force you out of the house or live with
Yes.
you and stuff like that, right? So what we're going to do is we're going to put it in trust, and then we're going to have, I mean, this is a technical term, we call it a QTIP, Qualified Terminable Interest Property Trust, right? So that gets
Mm,
created when one of you dies, and the only purpose of that trust is to hold your equity interest in the house. So one half of that house, in theory, is now held in this QTIP, and your spouse cannot uh, um, sell or encumber that interest unless the trust allows for it.
okay.
So usually, the way that works is we let the the surviving spouse, they get uh, they're entitled to all the income from the trust, and the reason we do that is because the tax rate for trust is really high. So we want to get the income out because half of it's going to go to the government if we don't get rid of the income. So that goes to the surviving spouse, and then the spouse can use the equity in your half for certain purposes. And usually the standard we use is called health, education, maintenance, and support. Right. So if they need to go into assisted living or something like that, and they need to borrow against, or maybe they need to sell the property, the trust is going to let them do that.
So, let's say Angie I'm dead. In theory, my daughter's still alive. Angie owns my property 50%. My daughter owns it 50%, but my daughter's not allowed to live in it, but my daughter wants money from it. Could she just go ahead and take, like, a HELOC? I mean, I don't think she could force Angie to refi,
Right.
but
So we would
how would that
normally
work?
not, yeah, we would normally not allow that to happen.
Okay,
You could draft the trust that way. Anything that if you can write it, you can put in the trust.
I see.
But we usually would not do that because the idea is you want the surviving spouse to have the unfettered use of the home.
Yeah.
And if you give someone the right to encumber it and they don't pay the that loan payment, that has to go in foreclosure.
Mhm. Yeah.
Right.
Yeah. Because if you gave, let's say, my daughter the right to do an equity line, which would probably be hard because she's not living in it anyway, so it wouldn't be owner occupied, but whatever, that's a whole nother conversation. Um,
Right.
but let's say that was possible. She took out $100,000 of equity. She's got this loan and she quits making payments. Now the second can go ahead and foreclose, which would put
Yeah.
Angie in jeopardy. So yeah, that wouldn't work.
Right.
Okay.
So I mean, for me, the analysis is simple,
Yeah.
right? If it's a primary residence, we're going to put it in a living trust.
Hmm.
And what happens to that house, that depends on the unique situation. Whether you have a blended family
Yes, we know trust is right for everything, but we're going through the
no, it's
the
not.
options of how to hold title.
No, it's not. Let's say you and I
And
decide we want to buy a rental property.
Uh, th yeah, this is actually perfect because, a lot of people don't do trusts, and they need to understand what why they should, and, the ways things can go wrong because everybody has a different situation in life, and it's just you just never know, so
Right.
you wanna make sure that, hey, this could happen because people don't think about the future a lot, and
Well,
just
they
bad
they
things can
don't.
happen in life, unfortunately.
But the way I conceptualize this is the first level of planning is no planning, and you're just going to let the government take care of it,
Mhm.
right? And that's intestate succession. That's probate. It's you're just handing everything over to a judge and say, Judge, figure it out. Then the
Yeah, that
next
doesn't
level,
sound like a good idea.
yeah, then the next level of planning is what I call a one size fits all plan. This is, you go
Mhm.
to the internet and pay a couple $100 to generate a trust document. The problem with this form of planning is that you can't insert any level of sophistication into the planning because it has to work for everybody that goes to the website.
Yeah.
And because it works for everybody, it doesn't really work for anyone.
Mhm.
So where this can work is, if you're young and you're unmarried and you don't have kids, and but you want to set up a trust and so that everything can be left to your brother or sister or your parents, you can probably do that just fine using a trust of that nature.
Yeah. Alright, let's bang through the rest of these, and then we can kind of, whatever other
Sure.
questions we have left. So the next is community property, and that's gonna be just in states that are community property, like
Right.
California, Texas, Arizona, looks like that's community property. I'm not sure whatever other
Right.
states
If
are,
you're in a
but,
community property
um
state, yeah, and you can
you
hold
can
it.
still choose though, if you're in community property, because I've seen people in California hold as joint tenancy. I've also
Mhm.
seen them hold it as community property. Now, then
Right.
you got community property, and then I've seen community property with right of survivorship. Now, in your mind, is that two different ways of holding title, or are you thinking even if it's community property, it's still right of survivorship? Kind of like you said with joint tenancy, because I've seen both.
Yeah. And I don't see a lot of difference in any of this. The same thing is going to happen to the property.
I thought if you just put community property on title, you don't get the step up in value. That's at least what I was told by an escrow officer in the past. Is that correct or incorrect?
If you're holding it in community property, and I believe you get the full step up in basis.
Because I was told it had to say community property with right of survivalship to get the full step up in basis.
I don't think you do. I think it's the opposite. I think once you have the right of survivorship, it basically operates as a joint tenancy. I'd have to check on that, but
All right, yeah, we better get clear on that one then.
yeah, but
'Cause
it's
that's kind of an important thing that I would like to determine. So, and we can
yeah,
kinda
I
add.
don't spend a lot of time thinking about it because I'm always going to put the property in a trust.
You get the answer, and at the end of this, I'll give the results, the findings for, whatever that is, and then that way we have it on the video as well. So, if you can do that, that would be cool. So then community property, yeah, so what's the difference between joint tenancy and community property? So let's go there.
Joint tenancy is whoever the other tenant um, is going to get the property. So if it's your spouse,
Yeah,
great. But
yeah.
let's say you and I buy a property with joint tenancy, your wife is not going to own anything.
Okay, correct, yeah. So joint tenancy is is normally, I mean, it's not normally because I've seen husband and wife do joint tenancy, but joint tenancy is probably better if you're not married to the person that you're buying the house with, where community property is probably better for a marriage or something. Is that like why would somebody choose one over the other? Or why would somebody, if I'm buying it as husband and wife, why would I not do community property? Why would I do joint tenancy? Because I have, like I said, I've seen both. And I don't determine how people hold escrow. I can't really give that advice. They have to kind of determine that on their own. That's why I wanted to do this video to really go into the details so people can refer to it and say, oh, okay, now I understand. This is how we want to do
So I
it.
got an answer to the earlier question.
Okay.
You community property with rights of survivorship, you get the full step up.
Yes.
All
Okay.
right, so
That's what I thought.
you're
That's what I
married.
was
If
told.
you're married, you'd use that rather than joint tenancy.
Okay. So let's pause for a sec. So joint tenancy with right of survivorship, you only get the half step up. Community property with right of survivorship, you get the full step up. So that's a big difference. Correct?
Right.
Okay.
Yeah.
Okay, cool. And then community property without the right of survivorship, that's different, right? Or is it not really?
Yeah.
Yeah, okay. Because if you don't add the right of survivorship, you don't get the step up. Is that correct?
Yeah.
Okay.
See, these are things I don't deal with on a daily basis.
I know. I mean, you do more trust.
So one of the things I want to touch on before we end this episode is that people buy real estate, and it's not always for primary residence, right? And that's we've been talking in the context of buying a
Yeah, and
house to
that's
live in.
for this, I wanted to really just focus on primary residence because we haven't really done that. We've talked a lot on investment properties and things like that. So I just wanted to, we know that we can do LLCs for investments and in other different ways as well. But this, I wanted to just, I got a client. Most of my clients buy primary residence, some investors, but you know, that's why I wanted to focus on this because not everyone knows how to hold title, and I think it can be very confusing for people.
Well, it is confusing, and there, other states have unique forms of holding title, and it gets confusing.
Mhm.
Um, from my perspective, the clients I work with, we're always putting the primary residence in trust because that gives you the greatest amount of control.
Yeah,
Uh,
and I get that, and obviously, we highly recommend that everybody does that, but not everybody does. So we have to come back down to the real world and say, okay, if you're not going to put it in trust, which I advise you to do, at least eventually, here's your options, here's the risk. Why, while you have it in the way that you're choosing, and
right,
then again, let's get you into a trust when you're ready. Because maybe they don't want to spend 2 or 3 grand, which is kind of ridiculous because you're protecting a $6 million, whatever it is, 600 $1 million asset. You should protect that. So
asset, and you're not going to take care of it. So,
yeah,
um,
like my house is in a trust, so I've taken your advice. So
yeah,
I
so
did it.
you're going to
And
have
go ahead.
a couple. They buy a new house, and then they're going to spend tens of thousands of dollars, putting in new flooring and painting it, and maybe put a hot tub in the backyard and all this stuff. But they don't want to spend the 2 or 3 grand to make sure it's protected from a legal.
Yeah. Well, the problem is I think, I mean, I know when I was a kid, I thought I was invincible. Nothing can happen. But as you and I
I
both
thought you
know,
were
that's
invincible,
not
man.
actually accurate. Things can happen. I mean,
Yeah,
my daughter passed away. So life is not a permanent thing. There are risks, if she could leave this planet is I can leave this planet tomorrow. It could happen. We just don't know. So
right. So then we get back to that question of caring, right? What do you care about? Well,
yeah.
hopefully, your spouse and maybe her kids and some other people in the world. But then you start asking questions. what happens if I become disabled? What happens if I pass away? You know, what do I want to see happen? And if you're trying to do that sort of planning by using the title, very limited. There's not a lot of options, right? So, um, you know, you can put someone else on title with you and let them own the property if you're not there. But there's a limit to how far you can get
Yeah,
doing
clearly.
that.
Okay. So I think the last question or the last option I think is tenancy by entirety. Is that an option?
It's an option, man. That takes me back to law school. Um,
What is that? And I don't think I've ever seen anyone hold it that way, but
yeah, um, uh, it's only
for
available to married couples,
okay, so it's for married couples. Let's see. It includes right of survivorship and provides legal protection against individual debts of one spouse. So what does that mean?
it I've never done that. I've never used that form of title.
I don't think I've ever seen it either, so
You just make a community property.
but ChatGPT gave it to me as an option, so
Yeah. Okay. Um, it's it 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 exists. I've never seen it used.
okay. And then obviously, the last 2 things was just trust, which we've gone over. We've discussed the importance of trust, and then business entities. Obviously, if you're buying it as an investment, you're not a business isn't going to own it as a primary occupancy. So you can't buy a house to
Right.
live in and put it in your LLC. You have to buy it as an
No,
investment and then
you,
put it in the LLC.
no,
I mean, I
you
guess
could
technically you could buy primary
use an LLC
occupancy
to buy it and live in it.
and transfer.
Um,
Well, no, I you can't. I don't know of any lender that will let me buy my property
See, that's a
primary
different thing. That's
residence and close in an LLC. It does I've never
well,
seen it. Maybe there's 1 or 2 out there, but I've never seen
right.
it.
The answer is you can do it, but the lender's not going to support you in it,
Yeah, okay, yeah, yeah.
right?
And
So it's doable.
I
I don't
can
know why you would do it that way.
yeah, exactly. I can do it for an investor if you're doing what's called, a debt service coverage loan or something like that, we can close in an LLC. So that's
Right. I
completely
mean,
different.
you're the
But
expert on on that product line, right? I
yeah,
don't.
yeah.
That's not my wheelhouse.
Okay.
But if I have $1 million and I want to buy $1 million house for cash and put it in an LLC, no one's going to stop me,
Okay.
right? And I can do that. I don't know why I would do that, but I could. Usually, when we're putting property in an LLC, it's an investment property.
Okay. So let's go back here. I want to clarify one last thing. So we have joint ownership and we have community property. Like I said, I've seen. Let's just stick with married couples right now. I've seen married couples do it both ways. I've seen them do it as joint tenancy, also, community property. I would have originally, before I had a trust, I did put it in community property with the right of survivorship. I feel like that's the best thing to do if you're a married couple and you don't have it in a trust. Um,
Yeah, if you're not, if for some reason you're just absolutely opposed to using a
or
trust, and
or you just don't have a trust yet, and you're going to eventually get a trust. Let's go there because nobody should be absolutely
I
opposed to
can
a
put a
trust.
trust in place this week. It's not like this big thing, right? It's like
Okay.
yeah. So if you came, I could have a trust in place before escrow closes,
Got it. Good to
right?
know. Yeah.
So if you have a client that's buying a house and they don't have a trust, and say you really should put it in trust, and if they schedule a meeting with me, I can have a trust done that week.
Okay.
And
That's
it'll
cool.
be sitting there waiting to receive a house.
Honestly, I didn't know that, so that's good to know. Cool. Okay.
Yeah. The one of the thing we should talk about is wh- something that's fairly common that I see quite a bit. People buy a house, put it in trust, and then refinance the property sometime later.
Yes, and
And
guess what
the,
happens when a lot of times it doesn't go back in the trust, and I've even been guilty of having that happen and not
right.
realizing
So
it. I did it
and
to
I,
myself. I had to put it back
yeah,
into my own trust
yeah.
for myself.
I don't know why lenders do that. I've never.
I don't know why either. Sometimes
Yeah.
they've
So
challenged me on that, and then, like, where they wouldn't, most of them will close in the trust, back in the trust, but there are some lenders where maybe I choose them because they have better rates at the time or something like that,
right.
and they've given me hassles on that, and then I have to basically help my clients get it back into the trust, which is, depending on where they live,
It
it
makes
could.
no sense to me because when you transfer back in the trust, they can't call the loan.
Mhm.
I mean,
No,
that'd be a violation
absolutely
of
not.
federal
Yeah,
law.
that's not even, ever gonna happen.
Right. So why does it matter? I don't know. But the important thing for the homeowner is to be aware that if I refinance my property, I need to verify whether or not the property is still in trust or whether they titled it to me and my spouse individually as tenants in common or joint, community property, whatever it was. And then I have to go through the process of retitling the property back into the trust.
Exactly. Mhm. And usually that just I mean, a lot of times I've had some lenders want to get the full trust documents, but usually I can just get a trust cert, and that should be
They're
all
not
you
entitled
really
to.
need.
Yeah, they're not entitled to the full trust.
Okay. So
What they
basically if a lender asks me to send them the full trust docs, tell them to F off.
Yeah, well,
We're gonna do a trust cert. Sorry, this is how it's done.
or I could refer them to the California Attorney General's office because they're violating California law,
Okay. Interesting.
right? So
Yeah.
what they're entitled to is what's called a certificate of trust,
Exactly.
right? So that's usually like a two-page document.
Mhm.
It's notarized. It
Yeah.
tells them, yeah, there is a trust, and these are the trustees, and but a trust is a private document,
Okay.
right? It doesn't get filed with the government. Nobody's entitled to look at it other than the what we call the grantors. These are the people that form the trust, the beneficiaries, the people who benefit from the trust, and the trustees. So whenever we do a trust, there's always at least three parties: grantor, trustee, and beneficiary, and they're the only ones who need to know what the trust document says.
Okay. So question for you, correct me if I'm wrong here. Let's say I inherited a property through a trust. Would they need to see the trust then to prove that I have ownership? Because I have had that come up before.
So there's a property in trust,
Let's say
and
it was my dad's trust, his property,
right.
he passed. I now own this property. I need to prove that I'm the owner of it. Would they need to see the full trust there, or is that
I
just
don't, I don't,
also? 'Cause
I don't know who.
I've had that come up, and they've asked for the full trust to prove that that client had ownership.
Let me run through the two scenarios. One is your dad leaves you the house in trust. So that trust still owns the house, but now you have beneficial use of the house. All right. So let me just walk through the scenario. So your dad passes, leaves you the house, but it's still in trust. So it's in dad's trust, and dad will have a successor trustee. Maybe it's you, maybe it's someone else. That trustee could go refinance the property, assuming a lender is willing to
E
work with them.
Well, yeah, I mean, let's say so I inherited the property, but it's still in the trust, like you said, but
Right.
technically I'm the owner. Now
No, you're not. You're
well,
not technically the owner. The trust is the owner.
okay. So I would be considered
All you
the
have to do is go look at the deed, filed with the recorder. What's the last deed say? And it's going to, say, uh, you know, Brandon Feco, trustee of the Dad's Trust, dated 1972.
Mhm.
Right? That's who owns the property.
Yes.
The deed tells you who owns the property. That's why we have the
Legally,
deed.
yes, I get what you're saying. However, technically, I'm gonna think I'm the owner because my dad
Well, you
gave
might
me
think
this
that, but
property upon his death. What's that?
yeah, just because you think something doesn't mean it's true. Because what the trust might say is, uh, uh, you know, I want the house to remain in trust for the benefit of my son, Brandon Feco, who may live in the house and enjoy it during his lifetime.
That yeah, that
But
makes sense. Yeah.
right,
Mhm.
but he can't sell it, he can't encumber it.
So with
Yeah,
that being said, because of that, they have to see the trust, right? To know if
no,
they can refinance and give me money.
no,
Who okay, why not?
because it's none of their damn business.
Yeah, but how are they gonna determine if I can refinance and pull money out then?
Because they're going to look at title and they're going to see who the trustee is on title, right? Because the way the title reads when you put it in trust is uh, uh, Chris Smith, trustee of the Chris Smith Trust, dated September 1st, 1983 or whatever it is, right? So now they know that. So now they know that. So now they know that the property is owned by the trust and that I'm the trustee,
So you
right?
just need to
They
prove
don't.
that you're the trustee.
It's on title. It's,
Okay.
so, like,
That that's
what
not
does it matter what the trust says?
I mean, that's not by my experience. I don't feel like it is
Well,
because
see, you're dealing with lenders, and I'm dealing with the
I
law.
know, and that's why it's a different conversation, but I have to have the conversation based on my lending experience,
So, right.
and
So
because
the
that's what
answer
it comes
is
down to is how do I get somebody money that inherits a house? And if they just inherited this house, it's like you said, Chris Smith, it says your name all over it, whatever, but let's say you're my
right.
dad and you are willing whatever you're giving me the house upon your decease, you die. Now Brandon Fico technically is inheriting this house through this trust or whatever, and I say, well, I have to
You keep
refinance it.
saying you keep ignoring the fact that you don't inherit the house.
Okay.
The house is owned and controlled by the trust.
I okay, that I mean that makes sense, but this is a real life situation and I have done this
I
before,
I, I get it.
you know.
Lenders have their rules.
And
The rules are not the
you're
law.
being technical because you're a lawyer. And I'm just being a stupid non-lawyer
Right.
verbiage guy.
Right. Well, you're
Because
your reference
I've
material.
never had a client come to me and say, "Hey, my father passed away and I now have he left this trust that the house is owned in." They always say, "I inherited this house through this
I
trust or
know
whatever, through money."
because
So I'm
they
just
haven't had
trying
the
to speak in
conversation.
like easy terms versus legalese, because people
Right.
don't understand legalese unless you're a lawyer. They make things
Well,
really complicated
the,
so stupid people like me can't understand it.
yeah. So the practical reality is, let's say I'm the trustee and you're the beneficiary. You don't go to the lender, right? You're not on title. They won't talk to you.
Well,
I go to the
I mean,
lender.
I've had to give a death cert to show
Yeah.
that this
Right.
person has passed and prove
Right.
that it is now I'm just bear with me and the the son now has rights to the property. There we go. Does that make sense? I've had to prove that and then give death certificates, and then we were able to refinance it that way, you know?
Right. But what you're describing is the son is the one who wants to do the refinance.
Correct. Because the dad
And
no
there
longer exists on this planet.
right. And so yeah, you're gonna have to prove that dad is dead
Hmm.
and that son now owns the house.
But at
Okay.
in your lingo,
But
the
the,
son will never own the house because it's in the
right. So
trust.
the scenario we're talking about is the son does not own the house. The trust owns the house.
Mhm.
So the son can't go to the lender and say, I want to refinance a house that I don't own. Right. You're not supposed to do that.
Well, what if I
The
want
way it
my
would
kid
work,
what if I want my kid to own my house and have all rights to it once I die?
right, then you transfer the house. Is upon my death, uh, transfer my house to my son.
That's what a trust would have to say.
Right. And so then
Versus
right. And so what the trustee would
okay.
do, the trustee would get the death certificate
Yeah.
and and record a new deed that this house is owned by Brandon Feco as a sole and separate property.
So the trustee would actually pull that out of the trust and now put it into the kid's name,
Right,
technically.
because that's what the trust says. Trust says give the house to Brandon.
Gotcha. I follow you. I mean, I completely understand what you're saying because let's say there's a scenario where somebody's super duper wealthy and they have all these assets in a trust, including the house, and they want to control everything upon their
Right,
death, and they don't want their kids, you know, cashing out and
right.
selling the house and doing a bunch of
Yeah,
cocaine and yeah,
right.
so,
We
yeah,
call that the dead hand, right?
yeah,
The hand that controls everything, you know. Um, but yeah, if the property is maintained in the trust and you're just giving beneficial use of the house, you don't own it, but you can
hmm,
use it.
yeah,
Uh,
okay,
that beneficiary doesn't have the ability to go refinance the property because
hmm.
that wasn't given to them.
Unless
Instead, the trust,
unless the trust clearly states we're titling this over to our son upon my death or
right?
whatever. Okay.
So
I have to
the
look at my trust and see how it says, what it says. Like,
yeah, so
yeah.
the way you refinance it is the trustee has to do it,
Okay.
right? And then
And
I
and
give
and
them
the trustee is, let's say, I mean, it could be anyone that I designate. I'm not gonna designate my children or anything, right? I
right,
would designate somebody that I trust and like my sister, let's say. But then what if she dies before I die? I have to change my trust again, right? If she's no longer on earth.
right. Well, you could update it if you're still alive. You can
Updated, yeah.
update the trust,
Mhm.
but your choices are you can identify an individual, a person like your
Yeah.
sister, to be trustee, or
What
you
if
can.
what if I don't update it? Let's say she dies and I die at the same time, and she's the trustee. What would happen then?
So usually, what we do is, or say what I do is that in the event there is no surviving trustee, the beneficiaries can appoint a trustee, right? And then you give them rules about who, like it has to be a CPA or a lawyer, or maybe if it's a big estate, a trust company. You know, you can,
If the trustee passes at the same time, now let's say my children are the ones who are inheriting, they can
right.
designate somebody new.
Well, see, this is where you have to go to the trust document. What does the trust document say? The problem is if the trust document is silent, it doesn't provide for a mechanism, you got to go to court and you have to ask a judge to appoint a trustee. So when I draft a trust, I always have a mechanism in place that if there's no living trustee, that the beneficiaries can choose a trustee and appoint them.
Okay, I see. That makes sense. And who would a judge choose if it got left up to a judge? Like,
So the way that works is typically the beneficiaries hire a lawyer. The lawyer files a petition with the court asking them to appoint a trustee and make in the petition they'll recommend one or more people for the judge to appoint, and then the judge will want to see the beneficiaries in agreement with that recommendation. And if everyone agrees, you're probably going to get that person appointed.
Okay. Cool. Awesome, man. I know you have to get going here soon because you got an appointment
I
coming up.
do.
So I don't want to keep, yeah, I don't want to keep you anymore. I think this was super beneficial. I feel like you answered all my questions and I think any other question that anybody would else have. So, thank you for your expertise. And if anybody wants to get a trust, feel free to reach out to Chris Smith at what is it? CS Law.
No, CLSLAW, Charlie Lima Sierra Lima Alpha Whiskey.com.
CLS. I always forget that L for some reason. CLSlaw.com. And yeah,
I wonder who has CS Law. They're going to get traffic now.
I know, right? CLS Law. Don't go to CS Law. CLS Law.
Yeah.
All right. Cool, man. Thank you, Chris. I appreciate it.